Good morning, students. Settle down, please, and let's get right into it. We have a lot of crucial ground to cover today. In this explainer, we're tackling the absolute core of industrial relations: layoff, retrenchment, and closure, along with their respective statutory compensation. Now, listen to me very carefully. This exact topic is your ultimate preparation for a guaranteed 16-mark essay question in your upcoming KSLU labor law exam. You have to understand the exact literature, and you must reproduce it with perfect structural discipline. So get your notebooks and your pens out, because we are starting right now. Here is our synopsis for today. Number 1, introduction. Number 2, the concept of layoff. Number 3, retrenchment in labor law. Number 4, closure of business undertaking. Number 5, key differences and comparison. And finally, number 6, landmark case laws.
Section 1. Introduction to Industrial Relations. Key aspects under Industrial Relations Code 2020, earlier governed by Industrial Disputes Act 1947, deals with situations where workers are temporarily or permanently deprived of employment. Okay, look here. When you start writing your answer script, I want you to double underline this introduction heading. Presentation is half the battle in a law exam. Now notice we have both the 1947 Act and the newly enacted 2020 Code on the board. Citing both of these is absolutely mandatory. If you only write the 1947 Act, the evaluator is going to think your legal knowledge is outdated. But if you only write the 2020 Code, you completely lack the historical legal context. You must cite both to score maximum marks. Ultimately, the core legal principle we are dealing with here is the deprivation of employment, whether that happens to be temporary or permanent. Section 2. The concept of layoff. Temporary inability of employer to provide work due to shortage of raw materials, power failure, breakdown of machinery, or natural calamity. The employment relationship continues. Now pay close attention to that phrase, temporary inability. A layoff is not a termination, it's just a suspension. And I instruct all of you to strictly by heart these 4 exact statutory reasons: raw materials, power failure, machinery breakdown, and natural calamity. If a factory stops working because of huge financial debt, that is not a legal layoff under this specific section. The evaluator is actively scanning your paper for these 4 exact reasons. Furthermore, underline the fact that the employment relationship continues. The worker is still an employee of that company. Worker entitled to 50% of basic wages plus DA, payable for maximum 45 days, subject to conditions. Let me give you a strict warning right now. KSLU invigilators and evaluators look specifically for these exact numeric values. If you write something vague in your exam, like half salary, you will lose marks. You must write 50% of basic wages plus dearness allowance, and you absolutely must write maximum 45 days. These numbers are the lifeblood of the statutory provision. By heart them immediately. Section 3. Retrenchment in labor law. Termination of service of a worker for any reason other than disciplinary action does not include voluntary retirement or superannuation. Let's do a deliberate classroom dissection of this definition. Retrenchment is a termination, meaning it's permanent. But look closely at the strict exclusions. If a worker is fired for stealing from the factory, that's disciplinary action. It is not retrenchment. If a worker simply chooses to leave, that's voluntary retirement, not retrenchment. If a worker reaches the statutory age of retirement, say 58 or 60 years, that is superannuation. Again, not retrenchment. This is a very frequent trap in 10-mark long answer questions. You have to explicitly list what retrenchment is not to prove to the evaluator that you know what it is. Worker entitled to 15 days average pay for every completed year of service. Notice or wages in lieu of notice. I want you to underline, highlight, and circle this phrase in your notes. Completed year of service. That is the anchor phrase the evaluator demands to see. If a worker has been employed for 10 years, they get 15 days of average pay multiplied by 10. And don't forget the procedural requirement. The employer has to give advance notice, or they have to give wages for that notice period in lieu of it. Section 4. Closure of business undertaking. Permanent closing down of business or undertaking ends the employment relationship completely. Guide your pens to write down this absolute finality. Meticulously contrast this complete legal finality with the concept of a layoff we just discussed. A layoff is a temporary continuum, right? The factory might open again tomorrow or next week, but closure is the absolute death of the business undertaking itself. The doors are locked, the machinery is sold off, the employment relationship is severed completely and permanently. Compensation similar to retrenchment. 15 days wages for every completed year of service. Students, recognizing this structural similarity makes by-hearting the provisions so much easier.
The legislature, in its infinite wisdom, recognized that whether a worker loses their job because they are surplus, which is retrenchment, or because the whole factory shuts down entirely, which is closure, the economic shock to the worker's family is exactly the same. Therefore, the same statutory formula of 15 days' wages per completed year applies equally right here. Section 5. Key differences and comparison. Let me announce this very clearly. This table right here is the highest scoring section of your exam script. When the evaluator sees a clean, logical comparison, they immediately award maximum marks. I strictly instruct you to use a ruler and draw this exact table in your answer script. Let's go through it. Under nature, layoff is temporary. Retrenchment is permanent termination. Closure is permanent shutdown. Under reason, layoff is inability to provide work. Retrenchment is surplus labor. Closure is business closure. Under employment, in layoff, it continues. In retrenchment, it ends. In closure, it ends. And finally, compensation. Layoff is 50% wage. Retrenchment is 15 days per year. Closure is 15 days per year. Embed these conceptual differences firmly into your memory right now. This table alone is going to secure you solid marks.
Section 6. Landmark Case Laws.
State of Bombay v. Hospital Mazdoor Sabha. Clarified concept of industrial employment and labor protection. Put your pens down for a moment and listen, because absolutely no KSLU law answer is complete with judicial precedents. If you submit a 60-mark essay without landmark case laws, you will simply fail to get distinction. So, here is the mandatory breakdown of this case. What was the background? The government argued that the JJ Group of hospitals in Bombay were not an industry because they provided a public service without any profit motive. If they aren't an industry, their employees can't claim retrenchment compensation under the Act. But what was the ratio decidendi, the final verdict of the Supreme Court? The court ruled that hospitals absolutely do fall under the definition of an industry. The absolute relevance of this case is that the court took a highly progressive interpretation to ensure maximum labor protection. By defining a hospital as an industry, those workers were granted statutory protection against arbitrary retrenchment. Now, when you write this in your exam, I instruct you to underline the parties' names, State of Bombay versus Hospital Mazdoor Sabha, and place it in a neat, boxed format to immediately command the evaluator's attention. Workmen of Subwang Tea Estate v. Subwang Tea Estate. Distinguished layoff and retrenchment. The facts of this case are absolutely critical for you to grasp. Here, the management of the tea estate was undergoing a transfer of ownership. During this transfer, the management tried to terminate their workers, but they pretended it was just a temporary layoff. Why? Just to avoid paying the full retrenchment compensation. Well, the Supreme Court saw right through this scheme. The verdict established a clear, distinguishing line. An employer cannot disguise a permanent retrenchment as a temporary layoff just to escape financial liability. The relevance of this case is monumental because it prevents the outright misuse of the layoff provision. Your KSLU evaluator specifically needs to see this case in your answer script to validate that you actually understand how courts stop employers from exploiting legal loopholes. Write this case clearly, explain the disguise of retrenchment, and secure your marks.
Section 7. Conclusion. Represent different forms of employment termination or interruption. Law ensures workers receive fair compensation and protection. Balances employer flexibility with worker welfare. Never leave an essay hanging, students. A highly structured conclusion is what secures those final crucial marks. To summarize what we've learned, these concepts represent different forms of employment termination or interruption. The law steps in to ensure workers receive fair compensation and protection, while carefully balancing employer flexibility with worker welfare. That balance is the philosophical core of labor law. Layoffs give the employer flexibility during a sudden crisis. Retrenchment and closure provide the worker with a vital financial safety net when they lose their livelihood. But as we end this session, I want to pose a final, provocative exam-style question for you to really ponder. Does the new Industrial Relations Code of 2020 truly achieve this balance? Or, by increasing the threshold limits for government permission, does it implicitly make it much easier for massive employers to fire workers under the guise of flexibility? Reflect on this critically as you walk into that exam hall. Best of luck with your by-hearting, and do exceptionally well on your KSLU examination. Class dismissed.